featuring 30
Good morning,
minutes
everybody.
of free legal advice. Call in now with your questions. 877-850-8585.
This is Vastola on the Law.
877-850-8585. Now here's your host, Attorney Jeff Vastola.
Well, good morning again, everyone. I'm Jeff Vastola, your host, here for the next 30 minutes to give you free legal advice. All you have to do is sit back and listen, but more importantly, if you have a question of your own, if you have something going on in your life and you'd like some free legal advice, now's the time to get it. You can call the radio show. You'll be live on the air with us. The number is 877-850-8585. Or if you're watching on Facebook Live, you can type your question in. I'll do my best to read the question as it's scrolling upwards. And if I don't get to you today, then I will respond eventually because I'll go back to the show and watch it and be able to take more time and see what people wrote in. But thank you for joining me this morning. Unfortunately, the ongoing saga with my father is that he's still on a ventilator, still unconscious. So for those of you that have been praying for my father, we thank you. We sincerely appreciate those prayers, every single one of them. And please continue to pray for him. And the good news is that he's been tested COVID negative, and so very soon we're hoping that he's going to be moved out of the room where we cannot visit him and be put into a room where we can visit him. He's been in the hospital for over 50 days now, and we just we can see him through a window because he happens to be on the first floor, which is something of a blessing, believe it or not. Because if he had been on the second or third floor, we would not have even been able to see him. So thank you. We appreciate all of your prayers. It is still National Impaired Driving Prevention Month. So what I'm asking everybody to do, if you have a young driver, it doesn't even have to be a young driver. Obviously, there's people drive impaired of all ages. But if you have a young driver, because statistically they're more likely to drive impaired, have some very frank conversations with them about how drinking affects your ability to react, affects your judgment making as you're driving. Same thing with drugs. I guess there's probably not a lot of kids that are going to admit that they're doing drugs, but point these things out to them so that hopefully you can prevent just one accident. We would be a much better society if we could eliminate impaired driving. Obviously that's not going to happen, but maybe we can take a bite out of it and prevent some of it. My daughter is 15 years old. She's almost 16. In a couple months she'll be 16, so she's been learning to drive. And just last night we were on I-95 together around 10 o'clock at night, and from a stretch of road from Donald Ross in Palm Beach County up to Bridge Road up in Martin County, very, very unfortunately, there's 3 different accident locations where I've represented 3 different families for the death of 2 18-year-olds and 1 girl that was 22. All young ladies, all died in vehicle accidents. All could have been prevented. 2 of which were not impaired accidents, but they were issues of overcorrecting and dangerous roadway. But the 22-year-old was a case involving an impaired driver. And so personally, I've seen the tragedy and how it can just absolutely wreck a family. So please, my plea to you is if you have a young driver, have a discussion with them about how you may only think it happens to other people, but you certainly don't want it to happen to you. You can find out more about me and my law firm by going to www.vastolalegal.com. Vastola being my last name is spelled V as in Victor, A-S-T-O-L-A. I've lived all my life with people spelling my last name with a B as in boy, so that's why I say V as in Victor. You can follow me on Instagram. I have a marketing director working for me now, and her name is Lindsay. She'll be doing a lot of our social media marketing only because I'm not that good at it. So I decided I would bring somebody on to help me, but you can follow us on not just Facebook, but Instagram and Twitter, YouTube. All of these videos are uploaded to YouTube and everything else. LinkedIn. If you're a LinkedIn professional and you'd like to communicate with me, then reach out. I'm always happy to do that. Most importantly, I make myself accessible to anybody and everybody 24/7, weekends, at night, it doesn't matter. Dial 833-VASTOLA. That's 833-827-8652. And that number goes directly to my cell phone. If I can answer your phone call, I will. If I don't answer the phone, leave me a message and I will do my best to get back with you. So that's about the extent of my self-promotion. I'm here I'm here to give free legal advice on Saturday mornings. I'm here every day of the week to provide representation to people that need it. So do not be too shy to reach out, and don't be too shy to call me on the weekend. Don't be too shy to call me at night, because in my field, personal injury, wrongful death, there are oftentimes reasons for us to talk immediately. So it's really important that you do reach out right away. So, topics for the day. As I mentioned, we are in National Impaired Driving Prevention Month. So do all you can to help prevent. I also am going to be talking about how you can own assets in the state of Florida for purposes of asset protection. So yesterday I received a phone call from a client that I represented a long time ago. He's just stayed in touch. Hi, Delita. Merry Christmas to you. His question was, well, these two boats that I used to own with my partner, now he's gone. Now the bank is saying the bank owns the boats. They want me to pay for them. There's a lot of issues embroiled in the telephone conversation. Unfortunately, really none of which I could help him with, but I decided to use that as my topic of the day because I do know that there are ways to own assets in the state of Florida that will give you asset protection so that creditors cannot come and take your things, at least some of them. So I'll be talking about that briefly. If anybody has any follow-up questions to those, I'll do my best. I may punt and send you to an asset protection specialist, but at least you'll get the basics today. And lastly, my trusty Florida Law Weekly. I'm going to be giving my case law update. I've got a couple of interesting cases in here. And so let's just jump right into it, okay? And if you have questions, please ask me. I have Facebook Live viewers from outside the state of Florida. Unfortunately, if you ask me a question, I'm going to have to tell you that my answer, if I give you one, is probably just a guess. I'm not licensed anywhere but Florida, so the Florida bar wanted me to tell everyone when I started doing a radio show 15, 18 years ago that I am only licensed in the state of Florida, so my advice is only good in the state of Florida. Now, I really have to emphasize that because people watching on Facebook Live could be in any state. They could be in any country. So, not that they are, but anyway, we're going to be talking about asset protection in the state of Florida. So essentially, and this pertains usually to real estate, but it doesn't have to be just real estate. It can also be bank accounts, and it can also be vehicles. It can be any kind of asset that has anything of value that you would want to protect. And so generally speaking, there's 4 ways to own assets, and these are going to be pretty common sense, I think, for most people, but you can own assets individually. You can own assets jointly. It doesn't have to be with a spouse. You can enter into any kind of an agreement to own assets with another person or other people. It can be multiple people. When it's joint, it doesn't have to be just one other person. But you can also own assets corporately. Just this week, as part of our tax planning that we do, my CPA recommended that we get another vehicle to take advantage of the, now I'm going to forget the name of it. It's an IRS rule that allows you to depreciate a vehicle, to take 100% depreciation of that vehicle in the first year. And as long as the vehicle is more than 6,000 pounds, it qualifies. And so for tax purposes, we did that. And when the dealership asked me, how are we going to title the car? I was very specific to say, well, it's going to be titled in the name of my law firm because it's going to be owned corporately. So that's another way to do it. You can own things corporately. And then lastly, you can own things in the name of a trust. If you have an existing trust, you can utilize that. If you don't have an existing trust, then you can create one so that your assets are in the name of a trust, which essentially means you don't own it. The trust does. But you can establish the trust in a way that it is meant to benefit you, sometimes exclusively. You can also create the trust so that it benefits other people if that's your intent. But those are the 4 general ways that you can own assets in the state of Florida. So, now, does any one of those necessarily give you asset protection? Probably the best one would be putting things in trust, but owning things individually, potentially owning things jointly, and potentially owning things corporately doesn't necessarily give you asset protection. For example, if I'm driving my vehicle that's titled in the name of my company, and if I cause an accident, then it's not just me as the driver that's responsible. It's also my company because they own the vehicle. Even though the vehicle's financed, because they're on the title, they necessarily own the vehicle. They're responsible because of Florida's dangerous instrumentality doctrine, which I've talked about quite a few times recently. If you have any questions about that, let me know. There is a statute that limits damages for the dangerous instrumentality doctrine if your liability is what's called vicarious to $100,000. So just make sure that you're adequately protected if you own a vehicle and somebody else is driving it. Make sure that you have insurance of at least $100,000 so that way you're protected based on the cap in the statute. So now, these types of assets that I'm going to be talking about and how you can utilize them in the way of for asset protection purposes are typically, very typically, real estate. But there's a Florida Supreme Court case I'm going to talk about that has extended this application to bank accounts at a bank. So essentially there are 4 different ways to own real estate or any other asset. Tenancy in common, joint tenancy. Tenancy in common and joint tenancy do not give you any asset protection. So then there's tenancy by the entirety, and I know these words are weird. They date back, I think, probably to the 18 or 1900s. But tenancy by the entirety is the best way to label your assets, to title your assets, to own your assets, so that you get the benefit of creditor protection. Because essentially what it says is the creditor of one spouse, say for example your wife causes an accident and you own your home jointly, but you the husband were not the driver, you the husband were not the owner of that vehicle she was driving, the person that she injures in this hypothetical files a lawsuit, gets a judgment against the wife only. In Florida, tenancy by the entirety says, well, if your judgment is only against the wife, then you cannot take the assets of the wife and the husband if, in fact, they're owned by in this form of tenancy by the entireties. And so you can also do that with bank accounts pursuant to the case of Beal Bank versus Almond and Associates. This goes all the way back to 2001. And essentially what this Florida Supreme Court opinion does is it says that even if it's not stated specifically, there is a presumption in the state of Florida that when married couples are buying real estate or opening up a checking account or savings or whatever, investment account, whatever it may be, the intention is that it will be a tenancy by the entirety's account, so that creditors of just one spouse cannot garnish that account and take money out of it. You have to have a judgment against both spouses. So in the event that you're interested in finding out more about tenancy by the entireties or how to potentially protect your assets, then give me a call. Like I said, I may punt. This is not something I do every day. This is just a topic that came up during the week, and I thought, okay, I'll make it my topic of the day. And so those are the basics. But if you're looking at stuff, if you happen to be married and you're looking at, your deed, and it's not designated as tenancy by the entireties, then you just may want to go talk to somebody about doing that. All right? Anyway, good morning to everybody that's chiming in this morning. Patty, Angela, nice to see you guys. Terry, I saw yours as well before it scrolled up. I want to talk about a couple of cases in here. This is the December 4th version of the Florida Law Weekly. The first case is out of the 4th DCA, which you guys are learning. The 4th DCA controls us here locally in Palm Beach County, but this is a case out of Broward County. And it has to do with a salesperson of a yacht filing a lawsuit against his ex-employer because the salesperson was not given the commission on a yacht. And I'm going to give more specifics about the case, but the takeaway that I want everybody to get is if you have any kind of a deal pending and you're relying on an oral agreement, try to reduce it to writing if you can. Okay, because this guy lost, and I'm going to explain the case, and I'm going to show you how much money he lost because he had to rely on allegations of an oral contract and then what we call an equitable claim of unjust enrichment. And the court, for its purposes in the analysis, said that he just didn't have the evidence, didn't prove up his case. But if he had reduced this agreement to writing, then I doubt a lawsuit ever would have been filed. I suspect that the commission would have been paid and there would be no problem. So again, a very important takeaway: if you're dealing in some professional manner where you're expecting to be paid for some work, put it in writing. This is a case of Merle Wood and Associates versus David Frazier. David Frazier is the salesperson, and it has to do with a super yacht. Now, what we learned from the opinion is that the custom yacht division of this yacht brokerage firm deals with yachts from 30 feet to 150 feet. Well, the super yacht division deals with yachts that are over 150 feet long. The yacht in question here is a yacht that was entitled, I didn't highlight the name of the yacht, Secret. That's the name of the yacht. So I don't know how long this Secret yacht is, but apparently it's longer than 150 feet because it's a super yacht. And the issue with the super yacht commission is that it has to be a custom commission agreed upon by Merle Wood, who's the principal of the yacht brokerage. Well, this guy Frazier worked at Merle Wood for a couple of years and then had constantly been soliciting this ultimate purchaser to buy a yacht from him, but he never consummated the deal. What happened was, after he left the company, well, actually before he left the company, for about a month, there was a little bit of overlap with a new employee salesperson that came in. And then when Mr. Frazier left the firm, he found out that the guy that came in for that last month while he was still there ended up selling this yacht called Secret to the same buyer that he had been soliciting for a very long time. And so David Frazier went to Merle Wood and said, I'd like the commission because you guys sold the yacht to the guy that I brought into the company, and it was sold, apparently shortly after I left. Merle Wood refused to pay a commission, and it says in the agreement that the commission itself, not the sales price, the commission exceeded $1 million. And in the custom yacht division, which is sales of yachts from 30 to 150 feet, the commission is 50% to the salesperson. But in the super yacht division, the commission could be different because it's custom agreed upon between the principal and the salesperson. So arguably the commission could be more than 50% on a total commission that exceeded $1 million. So they went to trial, and David Frazier presented evidence through an expert, and ultimately the legal analysis of the case is that the trial court allowed the case to go to the jury. The jury gave Mr. Frazier $0 on the verbal contract because essentially concluding there was no oral contract. But on the equitable claim of unjust enrichment, they awarded Mr. Frazier $300,000. Well, Merle Wood appealed that decision, and the 4th DCA, again sitting in Broward, Palm Beach County, Martin, St. Lucie, Indian River, and Okeechobee, did this full-blown legal analysis and said, unfortunately, although the jury said that Mr. Frazier was unjustly enriched to the tune of $300,000, he had not presented sufficient evidence to prove that. And so the appellate court took the $300,000 away from Mr. Frazier, and he's left with nothing. Now, his lawyers may be attempting to appeal this to the Florida Supreme Court because the 4th DCA is not necessarily the final say. But as of December 4th, 2020, when this was published, that's the status of the case right now. And again, the more global message to be sent from this case is put it in writing. All right? Now, let's move on to another case. And I haven't said this in a while, and I probably should repeat the number a little bit more frequently so people can call in. If you'd like to call into the radio show, because if you have a question, if you're in a similar situation and you want some advice, this is a great time to call. 877-850-8585. This is free legal advice. I'm Jeff Vastola, your host. I'm here every Saturday morning at 7:30 to give you free legal advice. Here's another case I found interesting. This is what we call a torts case. When you're in law school, you learn about torts. Torts are a civil wrong, negligence. It can even be intentional conduct. A tort can be intentional. But the main distinction is that it's a civil claim and it's not a criminal claim. And so if it's a criminal claim, it's the state that's going to prosecute the person that broke the law, and possibly that person's going to go to jail. In a civil case, somebody was wronged. The plaintiff is the one that was wronged, was injured, and files the lawsuit against the defendant. But torts, the category of torts is almost endless, the types of different cases that are under that category. But this is what's called a premises liability case, where a contractor was working at somebody's home, was there to trim trees, and apparently trimmed electrical lines and was electrocuted. And believe it or not, frankly, I'm kind of surprised this case was even filed. But this is a 4th DCA case. It's out of Fort Pierce. As I mentioned, Fort Pierce is in St. Lucie County, and so the 4th DCA goes all the way from Broward up to Indian River, which is Vero Beach, and others. But this is a case where the judge threw out the case on what's called summary judgment. If a lawsuit's filed, and if the defendant feels very strongly that the case never should have been filed, and has the evidence to support that, the defendant can file a motion for summary judgment to try to convince the court that this case should be thrown out. And that's what happened here. The defense attorney hired for the property owner that was sued, because the contractor showed up, admitted in, apparently probably in his deposition, the plaintiff, that he saw the electrical lines, but his contention was, well, the property owner didn't tell me that those were charged lines. I didn't know that. So having the evidence in front of it, the trial court in Fort Pierce said, I don't think it's reasonable that a contractor should have to rely on a homeowner to tell you that those electrical lines up there are actually charged. Don't trim them. I mean, why are you trimming electrical lines anyway? The contractor actually admitted that he saw the electrical lines, and it was his contention that he just didn't know that they were live. So anyway, but the general rule in the state of Florida, and here's a little bit of legal advice for everybody, is that a property owner is generally not liable for injuries sustained by an independent contractor or its employees while performing their work. An exception to that general rule is that a person who is having work done at his premises by an independent contractor and has actual or constructive knowledge of a latent or potential danger on the premises owes a duty to give warning of or use ordinary care to furnish protection against such dangers to employees of the contractor and subcontractor who are without actual or constructive knowledge of the danger. So this goes to the issue of the lines. The contractor admitted that he saw the electrical lines before he trimmed them, and the court decided, well, that's not a latent peril. It's patent, meaning it's obvious. And so that's why this guy lost. Anyway, this interesting cases that I find in here very oftentimes. If anybody wants to ask me questions about a case of your own, and perhaps you don't want to share it with everybody on the radio or everybody on Facebook Live, and you just want to try to reach out to me privately, you can do that anytime. Good morning, Uncle Mike. So 833 Vastola is a number that you can call me 24/7. I don't care if you call me on the weekend. I don't care if you call me at night. 833-827-8652. I know sometimes people don't like having to find the numbers that correspond with the name, but it's easier to remember. 833 Vastola. Call me, and I'm happy to talk to you about anything that you want. You can go to my website to find out more about us, vastolalegal.com. And remember, it is National Impaired Driving Prevention Month, so do everything that you can and help us prevent impaired driving accidents, especially over these holidays, because that's, of course, when, unfortunately, most of them happen. And remember, you don't have to be a young person to cause an impaired driving accident. You can be an older person at a holiday party not realizing that you've had too much. Share with your younger generation that Uber is always available, Lyft is always available, even the old-fashioned taxi cabs are available. There are a lot of taxi companies that offer free services during the holidays to cut down on the number of accidents. And if you're willing to tell your child, I'll pay for it. Just please, first of all, don't ever drive impaired. That's number one. But number two, very closely behind it, don't ever get in a car with somebody that's impaired. And that's a very strong message that I've given to my daughter and will give to my son when he starts getting into other people's cars, because it doesn't always have to be your child that's driving. So be very, very careful. I want to thank everybody for watching. Sharina, I know typically you're warning me that I'm getting close. How much time do I have left? Oh, I may have caught Sharina off guard.
1 minute.
Oh, 1 minute. Okay. So if anybody has any questions about tenancy by the entireties, which is, in my opinion, probably the best way to own assets in the state of Florida for the purposes of credit protection, please let me know. I'll be happy to answer those. But of course, there are other ways to own assets. And let me see. I hope everybody has a wonderful holiday season. Happy Hanukkah to those that celebrate Hanukkah. And Merry Christmas to those of you that celebrate Christmas. And Happy New Year to everybody. I expect I will be here next Saturday, the day after Christmas. So just be safe. And thank you again for all your prayers for my dad. Keep them coming. We really appreciate those. And God bless. Everyone, have a great week. Bye-bye.